a very small exception. So I think that's important to know too, because we keep hearing about all the litigation, and you did mention it. And isn't part of the reason that we end up in litigation because there's no real administrative body to serve as the final arbiter on CEQA. And in fact, it's a system that only can be resolved through the courts. You know, most things you get final administrative adjudications, and that essentially has its own enforcement mechanism. But with CEQA, the only mechanism is to go to court. Is that accurate?
That is correct. Once there's a final administrative action, either at the state level or the local level, depending on the project, any review by folks unhappy with that decision goes to the trial court, the Superior Court level of the state of California.
So if you go beyond the fact that originally everybody liked CEQA because it was going to deal with public works, and then the court said no, it applies to the development community as the private development community. Once you get by that philosophical disagreement with the private sector saying, wait a minute, this shouldn't apply to us, and the court saying yes, it does, and the legislature reaffirming that, if you're not going to deal with that issue and you just accept the fact that both, that development that has an environmental impact is going to have to come under scrutiny, is going to have to allow for public discourse and involvement, what would you recommend from your perspective as the best way to, I won't say restore, that implies that there's something wrong with the process, but to make the fundamental goals of CEQA more easily attainable? What would you recommend as a way that we could either procedurally or substantively so that we can maintain the fundamental principles of CEQA while bringing it perhaps into a more modern context?
Well, some of the things I think are quite simple and straightforward, and I frankly, 45 years into the statute, I'm quite surprised they haven't been implemented earlier, and this is really a segue into a bill that I know that you were carrying and that is before the committee, and that is SB 122. CEQA, enacted in 1970 before the internet, involves procedural requirements like posting a notice of the preparation of an environmental impact report on the bulletin board outside the county clerk's office. That type of notification has not been amended in 45 years. I believe it's a simple and long overdue step to bring CEQA into the internet age and digitize not only the informational process when CEQA is being complied with at the administrative level, but similar internet-based reforms could be adopted to litigation. And that's another point that the legislature spent a lot of time focusing on the judicial review component of CEQA and tinkering with that in various ways, which is one of the reasons that CEQA has expanded in terms of its length. But I think just those simple procedural technical reforms would be worthwhile and would both assist the interested public in that threshold purpose of CEQA, being informed and having ready access to the information about the environmental consequences of decisions, as well as helping to expedite the resolution of the litigation that does occur under CEQA.
Well, now, we did not have prior conversation, so that wasn't a softball that I threw with any idea of how you were going to swing at it. But I do appreciate those comments. But seriously, in addition to those really simple procedural things that appear in SB 122, part of the discussion is how do we expedite the resolution of the conflict, and that is something that, frankly, has been a challenge in looking at how we really modernize and make the program more efficient.
And a substantive response to your question, as a result of amendments to CEQA enacted some time ago, there is a requirement that immediately after a CEQA lawsuit is filed, that the parties, the enemy combatants, are required to meet and confer to determine if they can resolve the case. In my experience, the requirement that meeting occurs so quickly after the lawsuit is filed makes that a perfunctory and not terribly effective means of compromise and negotiations. I think deferring that kind of meet and confer session until a later time in the litigation, slightly later when the administrative record is prepared and when the issues are sharpened, would enhance substantially the chances for a negotiated resolution of the case, which of course is always the quickest and least expensive way to resolve litigation, through compromise, as opposed to requiring it to go all the way to judgment through expensive litigation on the merits.
Thank you very much.
Let's go to Senator Leno first, and then Senator Pavley. Just a brief question. Also, thank you, Professor. Great background information for all of us. And unlike my colleague, I do not have a bill. So this is just trying to make some sense out of all that you've shared with us today. Have there been attempts, and would it be a worthy attempt to create some new non-judicial review appeal administrative opportunity before we get to the courts? So we've tried to streamline the judicial process and fast track those that have certain thresholds met, but might we create something in between?
The legislature, of course, could. I'm somewhat skeptical that it would have much of a positive effect. I think the closest analogy that I can think of as a veteran of state government is the Office of Administrative Law, which in the rulemaking context, agencies are required to go there for a final administrative review to make sure, among other things, that the regulations that are proposed in a particular instance are faithful and within the delegated authority of the enabling legislation. I'm not sure how that would work effectively in the context of administrative review. My sense is that neither state or local governments nor the development community would be comfortable leaving the resolution of CEQA disputes to that administrative body in the ultimate instance without at least the opportunity for judicial review. So I think that would likely, such an administrative body and super administrative review would have the effect of further lengthening the CEQA process, which I would submit neither side would be anxious
to what
about.
we're trying to get to. But did I hear you say, and I may have not grasped this entirely, that CEQA is unique, if not uncommon, to most other state laws, and that it immediately goes to the court?
No. I did not mean to say that. In most states, certainly with the National Environmental Policy Act, there's judicial review of decisions of the federal government compliance with the National Environmental Policy Act. What I meant to say was that the unique feature of CEQA is that in addition to providing a procedural construct and the preparation of environmental documents that you're going to hear about from the other witnesses, what is unique about CEQA compared to the National Environmental Policy Act and most other states' little NEPA statutes, not all but most, is that California's has substantive effect in that it requires state and local decision makers to mitigate or avoid identified adverse environmental impacts to the extent it is feasible to do so. That's the unique aspect of CEQA.
Thank you.
Senator Pavley.
Yes, I missed the beginning, so just interrupt me if you already addressed this. Wondered if you had some statistics to show who actually is filing or funding CEQA lawsuits. I know in my little hometown, it's actually the rival businessman who doesn't want competition, either himself filing it or funding all for the friends of the whatever to file the lawsuit. Didn't know if you had a breakdown on, has that changed over time? We also know that other groups file for their own purposes that may or may not be directly relevant to.
Yeah, the short answer, Senator Pavley, is I have not conducted such a quantitative analysis, nor am I aware of one. I think it is fair to say that in the last 15, 20 years, we see more so-called non-traditional groups, not environmental groups, not neighborhood associations, but other groups utilizing CEQA to advance other ends which may be perceived as legitimate or illegitimate, but their economic interest, whether it's business competitors, as you mentioned, or the development community may be concerned about a government decision that is perceived as pro-environment and use CEQA as an opportunity to bat that down. There was another famous recent decision, of which I'm sure you're aware, the Save the Plastic Bag Coalition,
yes.
where the plastic bag industry utilized CEQA to challenge the city of Huntington Beach, I believe, plastic bag ban on CEQA grounds. I'm actually teaching a course in ocean and coastal law this afternoon, and I'll be teaching a class, a case in which the commercial fishing industry in California attempted to use CEQA to block an effort to implement the legislature's Marine Life Protection Act protection set-aside areas. So that's another key point that I did not make explicitly. CEQA litigation is often filed not only by environmental conservation groups, but also by industry. It's a equal opportunity environmental statute, I guess, and that has been, if I can go to the thrust of your question, that has been quite controversial. Although in that same California Supreme Court decision, Save the Plastic Bag Coalition, the California Supreme Court basically rejected efforts to limit standing, the ability to bring the suits to, quote, more legitimate or traditional applications of CEQA, and basically said under California's broad standing rules, anybody can, pretty much anybody in any interest has the authority to challenge government action under CEQA.
That's been interesting, sort of how that's sort of gotten away from the original intent at the beginning.
And period.
And the state Supreme Court's recent decision, I don't know if you touched on last, I believe it was last August or last fall, relating to circumvention of CEQA by collecting signatures for an initiative, and then that initiative really never gets on the ballot. The local government can decide, by majority vote, whether to adopt the initiative that allows the building, whether it's a football stadium or whatever it is, right? It's broad in its intent to move forward without CEQA compliance. Is that correct?
Yes, that's the Tuolumne County case from last fall, and that really is a good example of the courts, the reviewing courts, struggling to reconcile the provisions of CEQA on the one hand with California election laws, and in that case in particular, the justices were struggling mightily to try and reconcile the right of referendum and the California election laws with CEQA, and sometimes the court makes some difficult and controversial decisions in striking that balance.
So the people signing the initiative, I assume, are under the assumption that there will be an election where they would vet the merits of the project back and forth, but they never.
In that case, the Board of Supervisors, City Council basically embraced the initiative measure, which I understand was financed by the developer involved.
That's right.
And
the signatures are financed by the developer.
Right. And there have been efforts, there have been proposals brought before the legislature to limit standing in CEQA suits in response to those criticisms, and to date those efforts have not been successful.
Thank you. Thank you.
As your final thought, the Tuolumne case that you're talking about, that is the law of the land now in California.
It is the law of the land, but I think the Supreme Court was itself explicit in recognizing the legislature has the ability, if it is dissatisfied, just as the case 40-plus years ago with the Friends of Mammoth decision, CEQA is a statute, and the legislature has the ability to have the final word should it choose to modify CEQA, or in this case,
or require
the
that
state
it
election
actually
laws.
goes to the ballot or something.
Yes.
I don't think that was missed by anybody on this committee. Thank you, Professor, for your testimony. We will move on to our next speaker.
Thank you for the opportunity to testify.
Thank you. I'd like to invite our second speaker, Terry Rivaplata, with the Association of Environmental Professionals. Good afternoon.
Good afternoon. Thank you, Mr. Chairman. Or actually morning, I guess.
Yeah.
Still morning. Whatever. It's afternoon somewhere in the world. It's right. Yeah. I'm going to talk about kind of the CEQA process and give you some background on that. I actually work for ICF International. I'm a CEQA consultant as well as representing the Association of Environmental Professionals. So I write CEQA documents daily, that sort of thing. I've been in the business about 35-plus years, working on CEQA and also working for local government. About 16 years ago or so, during the Wilson and Deukmejian administrations, I was in the Office of Planning and Research. I was chief of the State Clearinghouse at one point, chief of the planning unit there at one point. I had a hand in the general plan guidelines updates in the 90s, as well as all of the CEQA guidelines updates that were done during the 1990s. So I have a long time history in all of this stuff. So a couple points, I guess, before I start. One thing I wanted to mention to kind of played around the edges of it earlier is that CEQA is a process, as Professor Frank mentioned, but it isn't a permit. That's one thing that's different about CEQA. It's a process, but not a permit. So it informs decision makers. It does not give anyone the ability to approve a project or deny a project. That's still left to the decision makers. So this process that we go through is for purposes of providing information to the public and to decision makers, and also, as Professor Frank mentioned, identifying mitigation or alternatives that would reduce the impacts, and that mitigation or those alternatives have to be incorporated into the project if they're feasible. So with that, CEQA has, I guess I'll talk about the short and the long of CEQA is what I'm going to be talking about. CEQA has short approaches to review of projects and long approaches to review of projects. There's three basic levels of CEQA review. The easiest sort of review are things called exemptions. They're statutory exemptions. There are what are called categorical exemptions. They're effectively ways of avoiding having to do the CEQA process in the case of categorical exemptions for projects that are generally benign, innocuous, smallish projects that under most circumstances would not have any impact on the environment. An agency simply declares that the project fits within the 4 square corners of a categorical exemption and then can move forward to approve that project or deny it if they want. Statutory exemptions are exemptions that are created by the legislature. They can be very simple and easy to comply with and all-encompassing. For example, there are exemptions relating to what do you call them, grade crossings that allow grade crossings to be built without CEQA documents being done. We had, as you mentioned earlier, now expired that exemption for the LA Olympics. You can create any sort of exemption you want at the legislative level, and it can be detailed, it can be less than detailed, very broad, very narrow. We also have an exemption that has been on the books for a number of years. It's hardly ever used. We have an exemption for infill development. There are 3 or 4 different varieties of that particular infill development exemption. It's been used no more than a handful of times around the state because it's quite complicated. It has a lot of hoops to jump through. So there's this idea of exemptions, which is generally the simplest approach to CEQA compliance. Projects that can't qualify for exemptions would then be required to prepare either a mitigated negative declaration, or an environmental impact report. So the second level of CEQA analysis is this idea of the negative declaration or the mitigated negative declaration. In either case, even though it says negative declaration, it's actually a positive declaration, where it's the agency declaring that they've looked at all the evidence in front of them, and there's no evidence that indicates that the project may have a significant effect on the environment. Or if there was evidence, they have feasible, fully enforceable mitigation measures that will avoid the potential for that impact. So mitigated negative declarations are actually positive things. Failing that, if the project doesn't qualify for that, and we'll talk a little bit later, or I'll talk a little bit later about how you fail, the next step in the CEQA process would be preparation of an environmental impact report, the thing that we know and love and that everybody talks about. That's a much more detailed discussion of the potential impacts of the project. It's also required to look at alternatives to the project that would lessen or avoid its impacts. It has a much longer and more detailed, much longer review periods, that sort of thing. So it's a more complicated, longer process than either of the other two. Your backgrounder that was prepared by staff is excellent, I thought. I read through it. It has a nice little chart in there that shows the CEQA process. It's basically a 3-step process. The first step is agencies will ask themselves, is this even a project for purposes of CEQA? Because not all projects are CEQA projects. CEQA only applies to discretionary actions by public agencies. So if the agency isn't discretionary, if the action, I should say, isn't discretionary, CEQA doesn't apply. Doesn't generally apply to administrative actions. If we wanted to remodel this room, for example, probably not subject to CEQA. If we wanted to tear down the Capitol and build something new, probably is subject to CEQA. So administrative actions, not subject to CEQA. If I'm the new city manager of the city of Rivas Plata, named after myself because I've just founded it, and I decide that I want to combine the planning department, the police department, and public works because they all start with a P, and make one person my director of that, I can do that without CEQA. It's administrative action. So it applies only to discretionary actions of public agencies. Once the agency knows that this is a CEQA project, and it's generally pretty easy to know, they'll decide whether or not an exemption applies If no exemption applies, then step 2 of the process would be preparation of what's called an initial study. Your backgrounder has, towards the back there, what's called the initial study checklist, and is an outline for agencies to follow when they go about preparing these initial studies. It's not a mandatory list of things to look at, but it is a model that offers them the opportunity to take a comprehensive look at the various sorts of things that this project may impact and check off boxes and provide documentation as to whether or not the project would have any of these sorts of impacts. The outcome of that initial study will generally lead to the decision to either prepare at this 3rd stage either a negative declaration, mitigated negative declaration, or an environmental impact report. So who does all of this? Who are the participants in the CEQA process? As the process is going along, there's what is called the lead agency. It's the public agency that is either issuing the permit or approving the project, or if there's more than one agency that has responsibility for permitting a project, it is generally the one that will act first. So for example, if I were proposing a subdivision map, that requires approval by my city or my county in order to be able to subdivide my property. If my property is located, let's say, next to a stream and I need to get a stream bed alteration agreement before I could actually build there from the Department of Fish and Wildlife, they would not be the lead agency. The lead agency would be the agency that acted first, the city or county, to approve my subdivision map. So we have a lead agency running the CEQA process, making all the key decisions, preparing the environmental documents or contracting for them to be prepared, taking the responsibility for adequacy of the document, taking the hit if there's litigation over the document. Then we have kind of surrounding that a whole variety of other players. We have what are called responsible agencies. Those are agencies that would be issuing permits for the same project at some future time. They would be using the same environmental document that the lead agency prepared. So for my subdivision example, if the city of Rivas Plata prepares an environmental impact report for that subdivision next to the stream, the Department of Fish and Wildlife would use that same environmental impact report when determining whether or not to approve a stream bed alteration agreement for my work in the stream. We also have consultants kind of hanging around the periphery. They do a lot of work nowadays for cities, counties, other agencies in doing special studies that may be necessary, air quality, biology surveys, cultural resources surveys, all that sort of stuff. We also have the concerned public. We may have competitors to the project. We certainly have, who else? Other agencies that may be concerned that are not necessarily responsible agencies. Cities and counties, for example, may be at odds with one another. 2 cities may be at odds with one another. They may be interested in each other's projects. They would be involved. And then sort of hanging out on the periphery of this whole little whirlpool of a system is the court system. The courts only get involved if there is litigation. They don't oversee CEQA at any point. As we mentioned before in previous testimony, the number of cases that pop up with regards to CEQA are actually rather small number of cases. We don't know offhand what percentage, I should say, of all the projects are subject to CEQA litigation, in part because we don't know how many projects there are.